Hey, okay, so chapter 9 is on negligence, primarily, strict liability, barely. We're going to mostly talk about negligence, and this is a really important area of tort law, especially for businesses. Of course, last chapter, chapter 8, was intentional torts. Negligence now falls into the area of unintentional torts, right? We're missing that element of intent when it comes to negligence. And yet, in either case, if you cause a harm, then you are going to be potentially civilly liable, you know, to compensate for that harm, whether it be compensatory damages and or potentially punitive damages. And this is important in the area of business because of the legal principle known as respondeat superior, which is essentially you're responsible for the actions of your employees or the actions of your agents, perhaps. So important to keep in mind these various torts, not only for yourself but for potential employees that you may have in the future. So a working definition for negligence is failure to do what a reasonable person would do under the same or similar circumstances. The failure to satisfy a reasonable person's standard of care. And that's fine to use that definition, but really, when you think of negligence, you think of the elements of negligence. At least I do, and you should as well. You should think about the elements that are necessary to prove a negligence case. And that is duty, breach, causation, and then damages. These four elements all must be present in order to prevail in a negligence case. And so let's just take each of these one at a time. You can see there a brief definition for each of those elements, but specifically we'll look at duty. For duty, the idea behind duty is it's a reasonable person standard. The idea is, are the actions that you're taking, typically somehow, somewhere out in the world, out in society, are those actions, could those actions potentially cause harm to another? So we use a reasonable person standard to establish whether or not there is a duty, but duty also involves this idea of foreseeability. For example, anytime you go out and get in your car, there is the foreseeability that you could cause harm. And so you have a duty as you're driving your car to drive it according to the laws, to drive it in a safe, reasonable manner is kind of the idea behind it. And so duties can be created in just about any potential situation where there is a foreseeability that there could be harm to a third party, right? You're on the baseball field, you're on the golf course, you are cleaning windows, whatever, right? You've always then got to take reasonable care not to harm others. And if you breach that reasonable duty of care, that's the next element. But before we move on to breach, there are some special duties. Our book doesn't really go at too much length to talk about these, but professionals have special duties just by definition. So this would be someone like a doctor, or even an accountant, or an attorney. They have special duties. A therapist as well is another example of someone who has special duties. And essentially, the idea behind a special duty is that it automatically establishes, just by the nature of your profession, that there is a duty, and it's a higher standard of care. Clients of an attorney or patients of a doctor expect a higher standard of care, and that's not unreasonable. There's another type of duty that's established automatically, and that's premises liability. I just noticed that spelled wrong. But premises liability is essentially for property owners, and you break down into these three categories. Who would visit your property? We talk about invitees, licensees, and trespassers. And the duty of care, the standard of care, is greatest to smallest, right? So an invitee is somebody who comes on your property and they are there for business purposes, right? So you're holding out a business, and there's typically some sort of a profit motive, although churches or nonprofits would also typically be held to this standard, even though they're not open for business. Because you compare an invitee to a licensee. A licensee is coming onto your property, and they're more so just a guest, right? This is someone you'd have over your house for dinner. And so there's a higher standard of care for invitees versus licensees. And the book does touch a little bit upon a business visitor, but if you have a duty to protect visitors to your property when they are invitees, and you have a duty to protect them from known and dangers that you should have known about. I always use the example in class. If you ever shop at here in Southern California, if you ever shop at Ralph's or maybe Kroger, or is the parent company of Ralph's. But whenever I'm in Ralph's, it's inevitable that I see somebody with one of those big kind of mop/broom devices going up and down the aisles, constantly going up and down the aisles. And it's not so much that the floor is so dirty that they constantly need somebody cleaning it. The idea is what? Ralph's is being vigilant in making sure that there are not hazards in their store. Very common lawsuit is a slip and fall lawsuit, right? So some customer spills something on the floor, maybe doesn't say anything about it, walks away, and next thing you know, another customer comes along and slips, and you got a lawsuit. And if Ralph's is being diligent, and Ralph's is not expected legally to know instantly anytime there's a spill on the floor. But if Ralph is taking a duty, if they're using a reasonable duty of care, they're probably going a little bit even above and beyond. But the idea would be that they're being made aware of, and once they are aware of a spill, they do something about it. Whereas if you're a licensee, your standard of care is simply a duty to warn. And you don't have to take proactive steps. You can just tell guests to your house, hey, be careful. I don't know, I just broke a glass and there's glass on the floor. Or, hey, be careful when you turn the hot water on in the bathroom. It's really hot, it's scalding, or what have you. And then finally, there's trespassers. And believe it or not, there is a slight duty even to trespassers. It's the lowest standard of care. But you are not allowed to willfully harm trespassers. In other words, you can't set booby traps on your property, even though somebody's on your property illegally. And so you can't willfully or wantonly harm a trespasser. And there's also this other idea of attractive nuisance, which I'll perhaps get into later. So that's duty. Next is breach. Breach is fairly straightforward, but again, there's a reasonable person standard of care. And I believe I introduced this concept of a reasonable person earlier in the class, but the idea, this is an objective standard, right? There is this fictitious person out there that the courts look to make a decision, and this person is the reasonable person in our society. And so it is this composite reasonable person that doesn't really exist, and yet we would say as a society, what are the norms that we would want? Well, how would we want people to behave? And so that's who this reasonable person is. So would a reasonable person have left broken glass on the floor? Would a reasonable person have driven 65 miles an hour in a 35-mile zone? That kind of gets into negligence per se as well, but you get the idea. What we would look at this, look at the duty and say, okay, did you do something that is beyond what we would expect a reasonable person to do, thereby breaching your duty? And there's some special doctrines with respect to breach of duty. They're going to come up a little bit later, and they come up a little bit later in the textbook, a little bit later in the PowerPoint, but I thought I'd mention them now because I do want to make the connection that these two special doctrines are a connection with breach. And so anyway, we'll get to those